Can you tell the difference between a diabetic episode and a drunk driver? Does your job rely on your ability to tell the difference? Well, if you answered no to both those questions, congrats. The chances of you being sued by a diabetic father are quite low, but they're never zero. The same cannot be said for the Sebastopol police officer who arrested Jeffrey Callaghan on what should have been a normal father-daughter day out with his 6-year-old. Hey, I'm America's attorney. I've been a lawyer for 24 years. I've helped over 1.2 million people. Let's take a look at this federal lawsuit filed by Callaghan and the actually insane events that led up to it. According to the lawsuit, Jeffrey Callaghan is a 45-year-old father living in Sonoma County, California, who has battled type 1 diabetes since childhood. Managing the disease has been a constant part of his life, relying on insulin injections and a continuous glucose monitor to avoid dangerous drops in blood sugar. Now, on July 24, 2024, he was simply spending a father-daughter day with his 6-year-old shopping for toys and stopping for a Happy Meal. My dad never did that for me.
They ask you how you are, you just have to say that you're fine when you're not really fine, but you just can't get into it because they would never understand.
The pair was driving to a park in Sebastopol when his blood sugar began to plummet. His continuous glucose monitor, which should have alerted him, malfunctioned, leaving him unaware that he was slipping into a hypoglycemic state. The symptoms of hypoglycemia, confusion, sluggishness, and disorientation, soon took over. Other motorists, mistaking his erratic driving for intoxication, dialed 911 to report what they thought was a drunk driver swerving through town. Responding to the call, Sebastopol police officer Forrest Whitehall found Callaghan's pickup creeping along, barely maintaining its lane, before it drifted off the road and crashed into a ditch. It was not a high-speed chase. Whitehall immediately escalated the situation, drawing his firearm and shouting orders at Callaghan.
Police! Turn the truck off! Turn the truck off!
Callaghan, for his part, still slumped and dazed, barely responded. When Callaghan finally managed to open his door and slowly raise his hands, Whitehall threatened to use his taser and then fired, sending 50,000 volts of electricity into a man who was in the midst of a medical emergency in front of his screaming daughter.
Go down to your stomach right now or I will tase you. Go down to your stomach right now.
Callaghan fell to the ground as Whitehall continued shouting at him, deploying the taser a second time and a third time when Callaghan struggled to comply in his disoriented state. Backup officers, including Sonoma County Sheriff's Sergeant, arrived and forced Callaghan's face into the pavement. In the process of pulling his arms behind his back, one officer applied so much pressure that they broke Callaghan's arm. As medics arrived, they quickly recognized that Jeffrey Callaghan was not intoxicated, but instead was in the middle of a hypoglycemic crisis. They administered glucose, and within minutes, his coherence began to return. Despite this, Officer Forrest Whitehall, along with Sergeant Cameron Finsky and Captain James Hickey, allegedly began brainstorming ways to salvage the situation. And by salvage, I do mean manufacture criminal charges where there was clearly no criminal behavior and certainly no criminal intent. According to Callaghan's lawsuit, the body-worn camera footage captured Finsky telling Whitehall to work the DUI, the child endangerment, and the pursuit, while Hickey suggested writing reports in a way that would make Callaghan appear combative and resistant. At one point, Whitehall administered a field sobriety test and later wrote in his report that Callaghan showed signs of intoxication, claims that were directly contradicted by his own body cam footage, which showed no such impairment. When Callaghan voluntarily submitted to a breathalyzer, it read 0.000, but it only showed that because there wasn't any room for more zeros. That's as big as the screen gets. But even after that, Whitehall pressed Callaghan to submit to a blood test, which would also come back completely clean. Despite the mounting evidence that this was nothing more than a medical episode, the officers conspired to charge him with felony vehicular evading, felony child endangerment, and resisting arrest. They went so far as to file a suspected child abuse report with CPS to paint him as a danger to his daughter. Callaghan spent nearly 5 hours in restraints, including being cuffed to a hospital bed while medical staff treated his broken arm. A nurse reportedly questioned Whitehall directly, asking why the man was still being treated like a criminal when it was clear that he was suffering from a diabetic episode. Wow. I'd like that nurse on my jury. Nevertheless, Whitehall transported Callaghan to the county jail that night where he was booked as a felon. All of this occurred despite the fact that prosecutors would later reject every single charge against him. Hey, leave it to the lawyers to do the right thing. On February 10th, 2025, the Sonoma County District's Attorney Office officially rejected all the charges brought against Callaghan, including vehicular evading, child endangerment, resisting arrest, and even that initial stupid suspicion of DUI. In July of 2025, meaning last month, Jeffrey Callaghan, joined by his daughter through her guardian, filed a federal civil rights lawsuit against the city of Sebastopol, Officer Forrest Whitehall, Sergeant Cameron Finsky, and Captain James Hickey, and some unnamed John Doe officers. The complaint lays out a sweeping set of claims under both federal and state laws, including excessive force, unlawful detention, false arrest, false imprisonment, conspiracy to violate civil rights, deprivation of familial association, and supervisory liability. It also invokes California's Bain Act and negligence statutes. I mean, they threw the book at him. Central to the lawsuit is the allegation that officers not only misinterpreted a medical emergency as criminal behavior, which they obviously did, but then actively conspired to fabricate charges in order to justify their use of force and try to shield themselves from liability, which also they obviously did. At the heart of the case is the excessive force claim. Ninth Circuit precedent has long held that the use of a taser in dart mode against a non-resistant subject constitutes per se unreasonable force. Here, Callaghan had his hands raised and was visibly disoriented from hypoglycemia, not actively resisting arrest. The complaint cites multiple deployments of the taser, followed by physical restraint that broke Callaghan's arm, conduct that could easily be found unconstitutional by a jury, but only if the jury doesn't have their heads up their own butts. It's obviously unconstitutional. The unlawful detention and false arrest claims also appear strong to quite strong. Officers had probable cause to investigate erratic driving, but once medical personnel confirmed a diabetic episode, and then Callaghan blew a 0.00000 on the breath test, the legal basis for holding him just evaporated. Like, the legal basis went down to, what's that one number? Oh yeah, 0. Continuing to keep him in handcuffs for hours, fabricating signs of intoxication in reports, and booking him into jail after his medical crisis had been resolved undermines any argument of good faith. The complaint alleges that Sergeant Finsky, Captain Hickey, and Officer Whitehall openly strategized about finding charges after realizing Callaghan committed no crime. If proven, that demonstrates a coordinated attempt to shield themselves from liability by manufacturing criminal accusations, which is a classic civil rights conspiracy under Section 1983. Similarly, the claim for deprivation of familial association, brought on behalf of Callaghan's young daughter, is bolstered by the fact that she was separated from her father, placed in police custody, and subjected to emotional trauma. She observed their unlawful use of force on her disoriented father, despite the absence of any exigency or legitimate basis for denying her access to him. Now, the state law claims, including negligence and California's Bain Act, are equally viable, in my opinion. The POST training materials explicitly warn officers not to confuse diabetic emergencies with intoxication, and failure to follow that training could be deemed negligent. The Bain Act, which punishes interference with civil rights through coercion or intimidation, aligns closely with the facts alleged in the lawsuit. Repeated taser shocks, false charges, and an arrest carried out with actual knowledge of innocence. The lawsuit now enters its early stages in federal court, where the city of Sebastopol and the individual officers will be required to respond to the complaint. They may file motions to dismiss, arguing that some of the claims are not legally sufficient or asserting qualified immunity, a common defense in civil rights cases that shields officers unless they violated clearly established law. At the same time, the city may consider a settlement to avoid expense and public exposure that a trial would bring, especially since the prosecutor already declined all the charges and the body cam footage appears to corroborate the plaintiff's account. Quick sidebar on the body cam footage. I don't have any words for my sidebar. All I can do is shake my head. I mean, these officers, they're toast. The city and the police officers are going to lose the lawsuit. Whether that happens in a trial or by payment of a settlement is obviously up to them and their lawyers. But their use of a taser is completely shocking. That's the worst pun I've used in months, and I'm sorry I'm not sorry. They will try to say that they were being thorough and that they didn't mean to violate the law, but the video undercuts any meaningful possibility of a jury siding with them. We'll probably never hear about how this lawsuit ends because it will be a part of a confidential settlement. And I guarantee you that the settlement will be enough to buy Mr. Callaghan and his daughter a ton of more Happy Meals, and also a functioning CGM so that he doesn't have any more episodes like this. Hey, those are my thoughts on this situation. I'd love to hear your thoughts on Callaghan's arrest. Was justice truly served in a situation like this? Do me a favor and drop your pro se opinion down below in the comments and let me know what you think. And don't forget while you're down there to lawyer up with me, America's Attorney, by hitting that subscribe button. I'll be back soon with more legal breakdowns, and I want to see you then. Bye. The symptoms of in the middle of a hypoglycemic is not a word Josh Sanford says every day.